Hi friends, in contracts today we talked about the statute of frauds, but we talked about it with the U.C.C. And so that's really everything thus far has talked about the restatement, how the restatement has addressed the statute of frauds. We did introduce the U.C.C, but now we're focusing primarily on the U.C.C and we only have one case. And I debated about doing this, but I think I'm going to do it anyways. It's not too long, so I'm going to read the actual requirements under Section 2201 of the U.C.C. for the statute of fraud. So subsection 1 says, except as otherwise provided in this section, a contract for the sale of goods for the price of $500 or more is not enforceable by way of action or defense unless there is some writing sufficient to indicate a contract for sale has been made by the party between the parties and signed by the party against whom enforcement is ought, or by his authorized agent or broker. A writing is not sufficient because it omits or incorrectly states a term agreed upon which the contract is not enforceable under this paragraph by the quantity of goods shown in such writing. Then I'll skip ahead to 3 because that's what the other section of this case talks about. But Section 3 says a contract which does not satisfy the requirements of subsection 1, but which is valid in other respects, is enforceable if the goods, and this is if the goods are to be specially manufactured for the buyer and are not suitable for sales to others in the ordinary course of the seller's business, and the seller, before notice of repudiation is received and under such circumstances which reasonably indicates that the goods are for the buyer, has made either substantial beginning of their manufacture or commitments for the procurement, or B, if the party against whom enforcement is sought admits in his pleading, testimony, or otherwise in court that a contract for sale was made, but the contract is not enforceable under this provision beyond the quantity of goods admitted, or C, with respect to goods for which payment has been made and accepted, or which have been received and accepted. Okay, so just to sum it all up, Section 2201, Statute of Frauds underneath the U.C.C., Section 1 just says if it's a good over the price of $500, it needs to be written down by a sufficient writing. And a sufficient writing just means that the person who it's being performed against needs to have signed it in some way. And then Section 3, which we talked about in this, going to talk about in this case, specifically C, are the exceptions to the requirements set forth in Section 1. And the exceptions are if it's specially manufactured for the buyer, if the person admits that there is a contract, or with C, if there is partial performance or full performance. In respect for goods, payments has been made and accepted. Okay, let's go ahead and get into our case. We talked about Buffalo v. Hart. What happened here is that the person was trying to purchase some tobacco barns. And when you think of a barn, you typically think of a big, giant building, not really a movable object. But here, this tobacco barn is kind of more like a shed. It was very easy to sell and move off the property, but it was just staying on the property for sake of ease. Anyways, what happened here is that the plaintiff was renting these tobacco barns as he was working in the fields, and ultimately he put forth a desire to purchase these barns, and so he said, I'll give you $20,000 for it. I'll pay these in $5,000 installments for the period of 4 years. And to do so, he reimbursed them for insurance on the barns, all these kind of things, just to show that he had, in fact, made this contract to sell. The issue is that they didn't write it down, of course, and that's why we are here. So now we need to determine whether or not it follows our 3-step analysis of didn't meet the statute of frauds. So the first question that we need to ask is, did the statute of frauds apply? And here, the answer is yes. This is going to be a good, so it's going to fall underneath the U.C.C. And because it was a good more than $500, in fact, it was $20,000, the statute of frauds applies here. Is the statute of frauds satisfied? And the answer is no, because 2201 subsection 1 says that there needs to be a sufficient writing, and it talks about what a sufficient writing is here. When he paid for the first installment of the barns, he sent them a check, and this was the only writing that they had. He sent them a check, and they looked at it, he signed it for the barns, $5,000, first installment, $5,000. And he sent it to them, and they were like, no, we kind of changed our mind. So they sent it back, and they didn't sign it at all. Notice that this is who it is being enforced against. The plaintiff here is suing for breach of contract, so it's being brought up against the defendant in this case. But the sufficient writing is not there because the defendant did not sign the check, did not endorse the check. And even if they had, there's going to be questions about whether or not there were other governing documents that were sufficient to actually say that this was a contract. But in any case, they did not meet that requirement, and so there was not sufficient writing. And because there's not sufficient writing, it does not meet the statute of frauds. So the third question we have to ask is, because it doesn't meet the statute of frauds, is there an exception to the statute of frauds? And here there is an exception, and the court quotes the restatement in 2205 subsection 3 subsection C. The subsection underneath 3 is C that they quote, and they just say that says that it requires delivery by the seller and acceptance by the buyer. So what was delivery to the seller in this case? Delivery by the seller. Delivery by the seller was that it had simply gone into the possession of the buyer. He had been renting it for a time, but once they made the agreement to actually start purchasing it, at that point, he was using it for his own purposes. And so there was definitely a transfer of possession from the seller to the buyer. And there was acceptance to the buyer from the buyer, and his acceptance specifically was that he had gone out to find other people to purchase the barns from him. He had gone out to out of his way to make repairs in the barns. And he had also paid back the seller for the insurance that they had there. So the court says here that it meets this exception, and that because it meets this exception, it's going to go to a jury. And the jury needs to address whether or not there was a contract and whether or not there was a breach of contract and all the other stuff that'll go underneath U.C.C. 105. And so that is summing up the statute of frauds. Just note for when it comes to doing the statute of frauds that we need to always follow our 3-step analysis of whether the statute of frauds apply, whether it was met, and whether or not there's an exception if we need to get that far. And that is the end of our contracts material for the rest of the semester. It's been a joy. It's actually a little weird to think about not having any more contracts, but still have the final, and so there's going to be maybe 1 or 2 more episodes that comes out regarding some of the finals prep that I'm doing. But besides that, contracts 1 is done, and starting in January, nearly a month and a half away, we'll get into contracts 2. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.